It's our pleasure, Alfredo and mine, to have our two guests today, Sophie Tomlinson and Ajith Francis. They'll be speaking on security issues. Some of you may have attended one of their sessions with Bernard and others. They're doing phenomenal work. They've had a number of public sessions in Ottawa and elsewhere. So it'll turn over to you guys, and thank you for joining us today.
Thank you very much, Glenn, and thank you, Alfredo, for inviting us to speak at this session. So if we could go to the next slide, please, and the one after, if you can change the slide. Yeah, so just hi, everyone, and really great to see so many people joining from all over the world. So I'm Sophie Tomlinson, and I'm the Outreach and Communications Manager at the Internet and Jurisdiction Policy Network. I'm just going to start with an overview, really, of the context and the challenges that we are seeing as a multi-stakeholder policy network working on internet governance, and what you're studying at the moment, all the different security issues, but also economy, human rights, how they intersect, and why we need policy innovation. So I'll start with an introduction to our organisation and also talk you through our multi-stakeholder methodology. And then my colleague Ajith Francis, who is the policy manager at INJ, he will do a bit of a deep dive in the actual policy issues we're addressing that have a security dimension, and explain a bit how INJ is tackling those. So if we could go to the next slide. Thank you. So, as I'm sure you're all very, very aware, the internet is bringing up many transnational policy challenges. And as Vince Cerf, the co-inventor of the internet, has said, these legal challenges, solving these in a way that is good for the internet, is arguably just, if not more challenging than actually building the internet itself. So what we did, if you could go to the next slide, please, what we did in 2019, and I noticed this was part of your course materials for the security session. What we did in 2019 was we wanted to unpack what are the cross-border legal challenges facing today's digital economy, and why are stakeholders concerned, and what's happening? So we launched this Internet and Jurisdiction Global Status Report, and it really highlighted just how much we surveyed around 100 stakeholders, experts working on internet policy, and it really showed just how much cross-border legal challenges are increasing. As you can see on the slide, there was about over 90% of people saying this. And the concerns focused on, I guess, three things. One was the growing concerns over abuses, many of these with a security dimension. And as you may have seen in the report, it focuses on cybercrime, but also access to digital evidence, surveillance, cybersecurity, things like data breaches, hacking, foreign storage of e-government data. So many different growing concerns. But within this also, the report highlighted there's a proliferation of policy initiatives and actors from government, but also the private sector, trying to address these issues. And so a mixture of concerns and a mixture of many different activities trying to tackle these challenges is leading actually to increasing legal uncertainty. So that was a real strong message from the report. And if you could go to the next slide, please. So as a follow-up to this report, as I briefly mentioned earlier, we did a regional status report which focused on Latin America and the Caribbean. And we did this in cooperation with the United Nations Economic Commission for Latin America and the Caribbean. And what we found in this report actually very much echoed what we'd seen on the global scale, which was this sense that we are having a digital society, but that not addressing the jurisdictional challenges is very much coming at a high cost. And it's becoming the case now, it's not just about whether to regulate or how, but also by whom, and how can we actually have as much innovation as we've seen in the development of the technology as we have in the policy, that we can have in the policy making itself. So one of the key points that arose, as I said, from the regional and the global level was also this need for coordination, and the fact that many well-intentioned initiatives are taking place to deal with cross-border legal challenges, security issues being one of them, but actually there needs to be better coordination of policy-making responses to enable a better playing field and a better way for our digital society. So if you could go to the next slide, please. So this leads me to, with that context, this leads me to introducing our organization, which is the Internet and Jurisdiction Policy Network. And what we try to do is bring together companies, governments, international organizations, members from the academic community, and also technical operators, all around the same table and all under our umbrella to try to encourage legal interoperability in cyberspace. So if we could go to the next slide, please. So what we try to do is encourage policy coherence and legal interoperability. So what does legal interoperability mean? Because this is a phrase that we use a lot, and you may have also read about in some of your readings for this module. And legal interoperability for us means enabling different systems and policies to be able to talk the same language and actually be coherent. They don't need to be exactly the same, but they need to at least be consistent and be coordinated. So what we try to do is get the actors together to enable a way of policy making that isn't done in a siloed approach, but considers the digital economy, considers human rights aspects, and considers cybersecurity. And if you're looking at security as a topic for your work and your studies, one of the things that we try to highlight in all aspects of our work is that with any policy topic, you need to have wealth of expertise. You need to have a common understanding of what challenges are in order to be able to address them. So if we move to the next slide, please. So our mission surrounds three key pillars: inform, connect, and advance. So what we do is inform the debates, and this we do, as I mentioned, in the context of our Internet and Jurisdiction global reports on a global and regional level. And we also do this in a number of other ways through events. Last year, we were pleased to do global conferences with the African Union Commission and also the United Nations Economic for Cooperation and Development, UN ETLAC, and also our global conferences. So these events inform policy making and allow different regions and stakeholders to exchange topics and ideas for policy innovation. And secondly, connect. So again, this leads to the different events that we organize, but it also, our activities around connect are also about our policy working groups. And this is something that my colleague Ajith will talk about in more details later. But essentially, what we do is we connect experts from business, government, civil society, technical community, all different stakeholder groups to actually develop policy approaches and to frame key problems that they all have in common and walk towards collaborative solutions. And then finally, in advance, this is actually the work of our policy programs. So those actual concrete tools and collaborative resources that enable multi-stakeholder approaches and policy making. So if we can go to the next slide, please. So these next couple of slides, we can click through them a bit quickly, because this is just to give you an example of the different events we have. They're actually all online on YouTube. So if you did want to get a feel for our speakers, the type of topics we discuss, please check out our YouTube channel. And if we go to slide number 10, in the introduction to our organisation, I wanted to give you a feel of the type of institutions who are working with us. So if you could change the slides, please. You can see here that our global conferences are supported by a range of international organisations, and also we have government host partners that we've worked with. And then if you go to slide 11, this gives you a feel of, well, I think you're going backwards. Sorry, if you go to slide 11. Thank you. So slide 11 gives you a feel of our multi-stakeholder convening power. So these are examples of the organisations that fund our organisation, but it isn't a pay-to-play INJ. It is very much open to anyone with expertise and interest in internet policy making. But this is an example of the way we are able to bring together different initiatives and different types of stakeholders. Now, if you move to slide 12, please. So here is where we look at a bit more of the substantive issues that we focus on. So one of the things I mentioned before is that we find it very important that when stakeholders work together on a policy issue, they need to actually define the problem first. A lot of the time when you read in the media or perhaps different reporting on internet policy matters, a lot of it can be very heated. And we see it very important that stakeholders actually get around the same table and try to define their common problems. So not as problems they have with each other, whether that's government against government, company against government, company against company, but actually what are the problems that they all have in common? What are they all trying to achieve? So these three legal challenges were identified as being very important by INJ back in 2012 when the organisation was first convened, and they focus on very concrete issues, and I think all of them very much do have a security dimension, and each one also is a good example of one, why internet policy challenges are transnational, and two, why actually we need different stakeholders to share their points of view and experience to allow us to actually make correct and helpful and innovative policy decisions. So if we look at the Data and Jurisdiction Programme, this programme focuses on access to electronic evidence. So as you're aware, and I'm sure you've been reading how many criminal investigations now require access to electronic evidence. So what we try to do in this policy programme is look into how can we develop regimes that are efficient but also establish human rights protections. So that's what we focus on in that programme. And then in the Content and Jurisdiction Programme, so we all know how much content is increasingly on the internet, how we're all able to develop and present and engage with our own content and millions and billions of others. So as content on the internet grows and grows, what is the appropriate distribution of responsibility between public authorities and private actors? So since content that is posted on, I don't know, Facebook or another social media platform in one country may be illegal in another country. So where should that content lie, and whose decision making could actually delete or remove that content? So that's a topic that we're focusing on in the Content and Jurisdiction Programme. And in the Domains and Jurisdiction Programme, this is where we get into more technical issues and looking at the internet's technical layer. And as online abuses on the internet take place, many law enforcement officials actually are looking to registries and registrars to address this content at the DNS level and remove that. But what is the impact of that having? And is that actually the best way to address online abuses? So the question that we focus on in the Domains and Jurisdiction program is, how can the neutrality of the internet's technical layer be preserved when national laws are applied to the domain name system? And I'll post in the chat in a moment the types of actors who work on these topics with us, because they're very diverse from all over the world, from Africa, from Europe, from North America, Asia. We have people from law enforcement, companies, civil society. It's really a very representative and large group. So I encourage you to have a look at that, which I'll post that in the chat. So also just to note, while I wrap up on this intro part, some of the actual tools that we've been able to deliver and produce as part of this work in the policy programs. So as Glenn mentioned, a couple of months ago, we released Inj toolkits, which define the policy challenges that I have just mentioned, and also give an insight into the Inj methodology. So if we could go to the next slide, please. So these toolkits, which again, I'll post the links to these in the chat, they define the core jurisdictional challenges, and they also explain how we were able to develop the tools. And then finally, they provide many different types of resources for practitioners working on these issues, be they content moderation, DNS level action to address abuses, or cross-border access to electronic evidence. And if we could go to the next slide, please. So on this slide, it just gives you a feel of how much time we spent on these toolkits. And we wanted to show this because it does give you an indication of when you're working in a policy making organization, you know, getting agreement and building consensus can take time. And also it's the time of many different actors who have full-time jobs who work with us. So we're very thankful for all the different contact group members who worked with us. And if you could go to the next slide, please. Thank you. So this slide gives you an overview of the Inj methodology. So how we actually developed these toolkits. And the reason why I think this is important to share, because when you're looking at topics, for example, like security, data governance, as I mentioned before, content moderation, many different complex issues, to address them sufficiently, it requires a very coordinated, a very inclusive methodology. So how we did this was that by first identifying the actors from the different stakeholders or stakeholder groups that had expertise or actually were working on the topics that we'd identified, we pulled them all together and we started to frame their common problems, as I mentioned before. So we tried to start off with a very collaborative approach to addressing these issues. And then after that, we decided to actually set some common objectives. So once we'd understood the problem and actors had a common framing of the issue, we then started with setting common objectives and common needs, common guidelines. Where do we want to go? How can we address this policy issue? And then finally, we developed common approaches, which we call our operational approaches. And this document was released at the 3rd Global Conference of the Internet Jurisdiction Policy Network in June 2019. I'll also post these documents in the chat, and they really give a first overview of the types of norms, criteria, and mechanisms that actors can use to address the legal challenges. And then finally, our policy toolkits, which are very kind of a practical and educational piece of our work that we hope is going to have wide impact. So I'm just going to check before I hand over to my colleague Ajith, who will actually give us a bit of a deep dive and more of an explanation of the legal challenges I noted. Just want to check to see if there's been any questions in the chat. I can see already there has been some about the DNS work that we've been doing. I can see that Ajith has replied to that, so that's great. And yet the DNS Abuse Institute is definitely an organization that has been kind of inspired somewhat by some of the work that we do in our Domains and Jurisdiction Contact Group. And as Ajith said, Brian's symbolic of PIR, Public Internet Registry. He's actually the coordinator of our domains work. So we're very much aligned and working with them because it's very good work what they're doing at the Institute.
Sophie, I'm very interested in the history because it's so obvious to have this. You forget sometimes, who is behind the start of this concept. So did it start because many of these organizations have such diverse concepts of multi-stakeholders, and whether it's GAC or the security sector or government or the in the case of any kind of policing of the internet or ICANN or others. So how where did the initial? I know there's probably been always interest in coming up with.
Yeah, it's a very good question because this isn't an organization that came about because a treaty was signed or that kind of thing. It's been a very kind of ongoing development. So it started in basically by the co-founders, by Bertrand de la Chapelle, who you mentioned earlier, Glenn, is working for the French Ministry of Foreign Affairs, and then after that, being on the ICANN work. And his co-founder, a man called Paul Fellinger, who has experience working in journalism, addressing a lot of internet topics. So basically, Bertrand and Paul, they wrote a paper back in 2012, which really tried to signal an alarm and ring alarm bells on what they called a legal arms race. And they were saying, look, there's as much as there are, growing internet policy challenges that we all know and that are all developing, but another thing that we're not recognizing is that all these legal initiatives are proliferating, and there seems to be a big race by governments, by companies to legislate, develop policies to address these issues with very little coordination. So essentially, they basically wrote a couple of papers and tried to get meetings with many different actors in the periods of, say, 2012 to 2016. And then in 2016, they organized a conference of the Internet and Jurisdiction Policy. At the time, it was the Internet and Jurisdiction Project. And they started with a global conference where many governments, companies who also felt this topic of a legal arms race happening as being very important, attended this conference with civil society, technical community, as I mentioned before, all the different types of actors to identify what are the legal challenges and why are they important. And that's how basically we've kind of zoned in on the three different topics around data, content, and domains. And that's where it started, really. I mean, we were meant to have another global conference this year, but obviously with the pandemic situation, we're going to be pushing that back, very likely. But it's really within, I would say, our global conferences that have kind of formed and have been the kind of stepping stones to structuring our work.
Right. So going from on the history, thank you for filling in the gaps in my logic. Are you looking for partners on a local level or a country level? Because you're dealing with such a wide range of legislation and rules. So is this something moving forward the organization is looking for, sort of that local content or local partners?
Definitely, because I think what we're trying to do, and this is kind of coming through with because with our policy topics, as you say, they're very specific and they're very concrete. So we try to be as diverse as we can in our contact groups, but we also want to keep them a manageable size for them to be able to produce concrete outcomes. But in our work around what we call knowledge mutualization, which is essentially how we try to share knowledge within the network and exchange capacity and resources. And we're doing this through our status reports at the moment. And the regional status report that we did with you and ETLAC was a really great way to bring members of the internet governance ecosystem from Latin America and the Caribbean into the network and get their expertise, and also kind of have, a channel of communication and sharing. So we're also hoping to do the same for Africa with a similar kind of project around a status report, and maybe that would entail workshops and events. But I think with the toolkits that we have now, we are very much looking for partners and really suggestions from the community. And that's why if people on this call, if you have ideas of where you think some of our work could be useful, or partners that you think we should connect with, this can also be educational universities, things like that, where we would be very interested, because this is very much a growing network, and there's no restrictions in terms of seats and how many people we want to bring into the work we do. So
to also add to that, I would also say I think the focus of the work, as the name says, is internet and jurisdiction. It's focused on cross-border issues and not predominantly on internet issues that might have impacts on users in a particular jurisdiction. Or it's basically addressing the conflict between jurisdictions and the global nature of the internet. So we come at it from a very particular lens, and we're always looking for bringing in people who are working on these issues, as long as from that particular lens.
Exactly, yeah. One of the resources I didn't mention in my presentation, but it's important to flag, is our Inj Retrospect Database, which basically maps jurisdictional trends on a monthly basis. And this is a really great resource for people trying to stay on top of the latest legal trends. So I'm just going to post it in the chat. But yeah, if there's not any other questions at this stage.
Sophie, I'm sorry to interrupt you, but it seems like Mira Said is asking for an example of an issue, and if you can, share that with us.
An example of an issue. Let me just have a look on the chat.
I think it has to do with the focus areas and the issues which we'll just deep dive into in the next section.
Okay, great.
Yeah. So yeah, maybe Ajith, if you want to start with the issues, and then then that will probably be a good segue then into having some more questions and conversation, which is always great.
Yeah. Ajith, just to make it make sure, it seems like your mic is touching something and it's making some background noise.
Is this better?
Yes, it is. Thank you.
Perfect. So great. Thanks, Sophie and Glenn and Alfredo for inviting us here and for letting us speak. So before I start, let me basically just give you a sense of why is the Internet and Jurisdiction Policy Network addressing these three issues of access to cross-border access to electronic evidence, cross-border content moderation, and DNS level action to address abuses. So as I said previously, the first focus area is the organization addresses challenges and issues that result in a conflict between the global nature of the internet and national jurisdictions. In particular, we all know that whatever content we post online or whatever information that's posted on the internet is available globally. But the rules and laws by which this particular piece of content might be visible or accessible in different countries varies, depends on the national law. So that's the conflict between these two is the specific area where we focus on. And the three focus areas in particular, it's not just that they are cross-border issues, but they are also related with the question of addressing online abuse in three particular sets. One, at the DNS level, you need to mitigate an online abuse at the infrastructure level. This could be technical abuse in terms of DDoS attacks, botnets. There are multiple sort of threats that affect the actual infrastructure of the way with which we access information on the internet. So that's one element to sort of safeguard. And how do we have a framework that allows to mitigate that abuse is extremely important. Similarly, we focus on the question of content moderation because it results in addressing abuses at the application level on the internet. Basically, different platforms that allow users to produce and post content online results in a significant challenge with regards to what content is available where. How do you also address and take down content that might be that might be illegal or even extremely harmful? That's at the application layer, and at the third level, we focus on access to electronic evidence because states do have a legitimate right to provide public safety to its citizens. And as more and more of our services that we use are more digital, the need for digital evidence is increasingly growing, and more often than not, this digital evidence is stored in different parts of the world, and we don't have legal mechanisms to address these specific challenges. So this is predominantly why we focus on these three topics. Additionally, with regards to these cross-border challenges, frameworks for addressing these abuses, if these abuses were localized or nationalized, where all the actors, whether the abuse happens in a particular place where all the actors that are perpetrating the abuse are located in the same place, and all the actors that are trying to mitigate the abuse are also located with the same jurisdiction, it would be very, very simple and straightforward. You could use existing mechanisms like courts, police, notice and takedown regimes within a jurisdiction. It's a straightforward process. But when you have multiple legal jurisdictions that are at play, or when the abuse is spread across a large geography or across different countries, or different countries need to be engaged in the process of mitigating such abuse, we have a lack of institutional framework to address this. Additionally, because it's cross-border, there are two specific additional challenges in that sense. One is that there is a clash of norms. What is illegal in one country might not necessarily be illegal in another. So what is the geographic scope of any action that we take on the internet? Can country X determine, for example, that this is harmful in my jurisdiction, so we should remove this from the internet? Or can there be more mature responses or more graduated responses to such abuse taking into account the level of intensity and the threshold for that particular abuse? Similarly, it's not just about national laws. On the internet, you have a plethora of platforms that come from a diverse set of geographies. So how do you also address the tension between laws where country X might say something is illegal? For example, let's say blasphemy in a particular country is illegal, but the terms of service of global platforms might necessarily not recognize that as being illegal. So how do we address that particular challenge? Because in the lack of frameworks to address these challenges, we result in very extreme fragmentation of the internet where everybody enforces their laws on the internet, and there's a clash, and there's no mechanism to resolve these particular conflicts. So with that, let me get into to our first topic on the issue of cross-border access to electronic evidence, unless anybody has a quick question on the framing element or the introduction that I just introduced. If you have any question, you can speak now, or we can go into the first topic of cross-border access to electronic evidence.
Ajith, this is Alfredo.
Yes.
And I'm guessing that you're going to talk about encryption and how governments deal with that, and your organization works on that as well.
Well, I will tell you very quickly, I will definitely delve into the question of electronic evidence, but I'm going to keep encryption out of that particular question because encryption is one, there is no common consensus on how we address encryption and electronic evidence. And forget about consensus, there's also no technical solution by which you can, it's either encrypted or it's not. So it's a very difficult, it's a policy and a technical challenge to which there is no particular solution at the moment. And that's something that we are cognizant of. but that's something that we don't necessarily consciously address because we are not necessarily sure that there could be a policy consensus on that particular issue.
Okay, great. Thank you.
And to Mira, I see in the chat, yes, indeed, this is linked to criminal behavior, to when a law is particularly committed in a country, how does the law enforcement in that particular region have access to electronic evidence? So maybe that's a good place to start. I am an Indian citizen. I'm currently living in Germany. I use a Chinese manufactured device that is running American software, and the data is stored in multiple jurisdictions. So if I had committed a crime in Germany, or if a crime has been perpetrated against me in Germany, what laws will apply on the mechanism by which law enforcement can access electronic evidence that is stored on my device or on servers that are related to my device? Because there are multiple jurisdictions involved. I am an Indian citizen, so I might be entitled to certain privileges. The crime was maybe committed in Germany, and I am located in Germany, so German law is also definitely involved. Similarly, there is an American device that's that's in the mix as well, and the data is stored on American servers that are run by American services, probably in Ireland or in the United States. So what law applies to the collection of that or accessing that particular electronic evidence is the fundamental challenge that we are addressing. In particular, before we get, the evolution of the digital ecosystem and electronic evidence in particular is very stark, because we're no longer talking about evidence that is stored in one place that's physical and tangible, that you can go to a particular place, look at it, analyze it, and then come back. This is digital, and the amount of data that we're talking about is significantly much more than what we had, what traditional investigations were dealing with. Secondly, this wealth of evidence might be stored in multiple jurisdictions, and there are no clear ways to sort of access it. Whereas on the other hand, in the past, if there was a crime that was committed and it had to do with bank fraud, you could go to the bank and identify, this is the particular. If it was a robbery, you can go to the bank and identify that this safe was broken into, and this is the crime that was committed, and this is the evidence surrounding it. On the internet, it's completely different. In addition, there's also, what is the connection to the crime? Who has jurisdiction to investigate? Is it the place where the location where the crime was committed? If so, what role does the country where the data is stored has to have? So this is again complicated because of the different jurisdictions that are engaged. There's also the question of legal applicability. What law applies in terms of the release of evidence? If the crime was committed in a country and the victim is in that country, would that country's law apply on the request that is made to another country for requesting evidence? So let's say in the crime has been committed in Germany, the victim and the suspect are in Germany, but the provider that's controlling the data is based out of the United States. Should US law apply when the only connection to the case is the fact that the data is stored in the US? If these two laws do apply, then how do you address the conflict of crime? If, let's say, in the United States, this particular crime was not considered illegal, should the United States provide that particular that piece of data? This is very, in many cases, easy to say yes or no. But when you talk about a lot of countries that might not necessarily have the greatest track record in human rights or due process guarantees, it gets very complicated very quickly. If you could go to the next slide, please. So the traditional process by which countries would request assistance from other countries in accessing evidence, traditional hardcore evidence, was through something called mutual legal assistance treaties. So the mutual legal assistance treaties would work in this way, that you have law enforcement in a particular country that will go to that country's central processing agency with a particular request, and then that central processing agency goes to the Office of International Affairs, that will then get in touch with the country of the host country's Office of International Affairs, and there's a whole process of evaluating whether that request is viable or not, and then they would release that particular information. This process takes about 10 steps, and on average goes anywhere between 3 to 6 months. Now, this is this is also the same process that is applicable at the moment for electronic evidence. And that process has, one, become extremely difficult because of the sheer volume of requests that a lot of countries are getting, especially whether in the case of in this particular case, it's the United States, because a lot of service providers are incorporated in the US or have a relationship with the US, even if they are incorporated in Europe, though they might be global platforms. So in this particular schematic, one of the ways that we are addressing this particular challenge is to define what are the mechanisms by which the law enforcement authority in country A can directly make requests to a service provider in country B. What are the due process guarantees that need to be put in place for this? What are the things that the company that's processing a request needs to take into account? And what is the escalation path for when the country within which the company is incorporated needs to get involved? So, for example, the United States. Next slide, please. So the work that we've been doing is focused on two levels in this particular element with regards to defining the due process guarantees for direct requests. It is defining what does a regime for direct requests look like in terms of, for policymakers that are setting out a treaty or an agreement to provide access to electronic evidence, what are the things that they need to take into account? And also, what should law enforcement authorities within a particular country take into account when they are transmitting certain requests from their state to another? So at the regime level, there are multiple tiers in terms of defining what is the data covered. Is it just subscriber information, which is often used to identify a user? Does it also have to take into account that only specific crimes are included or excluded, for example, that the regime might allow for any crime that has a threshold of a minimum sentence of at least 3 years? Similarly, what providers are covered? Is it all providers that provide services in a particular jurisdiction are, let's say, mere conduits exempt from this particular regime in terms of not having any access to content data in particular? Similarly, what is the requesting state required to do to demonstrate that it's making a legal request? Does it need to be validated by a judge in every case, or are there specific situations where a judge might need to be involved, or can the law enforcement authority directly, without any independent or judicial validation, send out a request? If they are, what is the standard of proof in terms of how do you demonstrate that this is a particular crime in one country and that I have followed the necessity and proportionality standards and there is no other way that I can access this information? How do you demonstrate that? And who are the authorized authorities that can actually transmit that particular request? Similarly, once these requests are sent out, there are questions of, if let's say it's Facebook, how does Facebook know that a law enforcement provider in Kenya who is sending a request over a Gmail account is actually the person that they say there is? So what is the authentication mechanism by which we identify this actually is the legitimate person that the police officer in Kenya is the guy he says he is? And how do we ensure that the transmission channel is actually safe and secure? That you are that the data is not being compromised in the process of sharing it with the law enforcement authorities. Are there clauses that limit the use of that particular data after a particular period or after the trial has been completed? Similarly, how do you demonstrate that you have actually had the crime actually happened in your jurisdiction and you have a substantial connection to the crime to investigate? So these are some of the questions that we particularly deal with. And this is why we developed the cross-border access to electronic evidence toolkit. Can I have the next slide, please? So the toolkit is built over two pillars. One is the general structure and key regime components. This is largely targeted to policymakers to tell them and inform them that if you are contemplating a regime that facilitates cross-border access to electronic evidence, you can consider, or these components need to be taken into account one way or the other. You can customize them based on the needs of the regime, but these are the bare minimum components that need to be taken into account. Similarly, many countries don't necessarily explicitly not allow service providers to disclose information under voluntary practices. They're basically law enforcement authorities can reach out to service providers, and those service providers might not necessarily be restricted by law to provide voluntary assistance. This particular tool is extremely important for countries that are not necessarily being covered by electronic evidence regimes around the world that are being contemplated. There are three main regimes that are being contemplated at the moment. One is at the Council of Europe's Budapest Convention and the second additional protocol to that particular convention on cybercrime. There's the US-UK Cloud Act bilateral agreement, and there's the European e-evidence proposals that are contemplating these regimes. But there are a large number of countries that are outside these regimes that still need a mechanism to access electronic evidence. Otherwise, the extreme action that can be taken into account with such actions is data localization. So how can these voluntary disclosure regimes be leveraged by smaller countries and smaller platforms to facilitate the sharing of electronic evidence when it's justifiable and fair and safe enough to share? So that's the structure of the toolkit. Can we move to the next slide? In particular, as I mentioned, the toolkit is addressed to civil society and academia and hoping to provide them with a grid of analysis, informing states how regulations elsewhere have an impact on them, and preparing service providers and states with concrete recommendations to how they can produce and process requests for electronic evidence. At this point, if we can go to the next slide, which should be the next slide, the final slide on this section. Yes. I stopped briefly if anybody has any questions.
Yes, Ajith. In the chat, I wrote that I was wondering what's the role of GDPR in the process that you just described, and I can take into account that they are dealing with reformulating the usage of WHOIS or whatever database to access some information regarding the evidence when a situation or a crime is committed. Thank you.
So on the GDPR, it's interesting because the GDPR does put data retention limits on providers that are providing services in Europe. So that does sort of by law shrink the window within which that these platforms might actually maintain the amount of data that they have for X period of time. So that's one of the elements that the GDPR has, one of the impacts that GDPR has on service providers. But predominantly, the GDPR focuses more on users' privacy and defining the rules by which users are more well informed about the privacy impacts that they have, and it doesn't necessarily directly translate to specific restrictions on electronic evidence. On the other question of who is evidence, this is something that is ongoing. I can tell you that who is data that is predominantly accessible publicly at the moment predominantly includes subscriber information, or what is known as identification information. There is a large debate about not making this accessible to the general public, or to defining the thresholds by which law enforcement can make these requests to access such information. This is still something that's ongoing. I don't necessarily have much information on how far this debate has gone. This is a focus area that we hope to sort of address this year at the contact group to discuss in specific the role of e-evidence and WHOIS, especially in light of the European e-evidence proposal that's actually being at the trilogue process in the European Parliament right now. If that answers your question.
Yes, thank you. There's another question from Bill in the chat.
Yeah. How does law enforcement deal with the fact that data, even at the level of a particular data set, might be spread across servers in different countries? For law enforcement, very simply, the way they think about it, it doesn't really matter where the data is stored. It only matters which entity has access to that particular data. More often than not, increasingly, bigger platforms are also compartmentalizing their data in terms of storing or data that has to do with specific jurisdictions in one particular center. I know that large platforms like Facebook and Google have already done that, and they have specific legal points of contact for that receive such requests. This is an ongoing challenge. However, for smaller platforms who might not be able to develop such compartmentalization or be able to provide legal assistance in specific jurisdictions. So this is a key challenge that we also still continue to deal with it. One of the ways that we are focusing on is informing law enforcement on how electronic evidence in the digital age is actually stored and accessed.
I don't know. I'm scared. Gotta blame us for Sam.
Sorry, there was a lot of disturbance. So that's one of the ways that we work on, is to develop these toolkits that are practical tools for law enforcement to get a sense of how the electronic evidence paradigm works, and how to process requests, and what are service providers and the countries that the service providers are located in. What are they analyzing these requests based off? So that's if that answers your question. Okay, so maybe we move on to the domain name system very quickly, and to addressing how do we address abuses at the DNS level. In principle, the DNS level, I'm not going to go into much detail, given that I know that Graham and Brian have spoken before me on the question of DNS abuse. So in principle, the domain name system is sort of the phone book of the internet. So you can pick up a domain name, let's say ajithfrancis.com, and you want to register this. So you go to a registrar, probably like a GoDaddy, which is sort of like an aggregator or a middleman that can facilitate a transaction. You need to define what registry that you want your domain name to be on. Is it .com, .org, .edu, .net? These are the top level registries for it. These are global registries that have a contractual relationship with ICANN and managed by ICANN.
Similarly, lawyer said that when you were in your courtroom right now, you know
that. Okay. Thank you for muting. So yeah, I mean, you have the top level domain names, and then you have country code top level domain names, which are predominantly, more often than not, associated to a specific jurisdiction. So .eu, .uk, .in, .co. These are predominantly registries that have that are associated and have a very strong relationship with the country with which they represent, and more often than not have a very strong influence with the jurisdictional laws that apply to that particular registry. Once you have a domain name, and you can link that domain name to a particular IP address, so that it points to the contents on that particular IP address. So ajithfrancis.com. Whenever somebody searches for it, whenever they key in the browser this particular domain name, the browser is pointed to the IP address that is at my personal website. So the domain name and the website are actually disconnected from the actual substance. So the domain name is just a lookup function, whereas the substance and the content of the website is hosted at a name server somewhere else. Next slide, please. So in particular, on the DNS, why DNS abuses are something that's very important to consider is because there are two types of abuses here. There's technical abuse, which most GTLDs are required to address under their ICANN mandate, or are required to investigate rather under their ICANN mandate. And these include anything that might affect the technical infrastructure of the internet. So phishing, farming, fast flux hosting, malware, botnets, and spam when it is a means to deliver malware or phishing. Similarly, you have at the same time website content. So, somebody has some really bad content on their website. is it appropriate to take action to limit that particular website? That depends on the thresholds that you can define. Is it, if it's most registries and registrars will be happy to take action on website content abuse when it has to deal with child porn or thing that's significantly illegal in most jurisdictions. However, at the same time, the domain name is there's a large proportionality question when you're acting at the domain name, because acting at the domain name is predominantly a switch. Either you take action or you not. You cannot take graduated or nuanced action at the DNS level. You can either prevent the domain name from resolving on the public internet, or you can let it resolve. That's the only intervention that you can make. So there is a huge question of when you act on a particular domain name, to be very clear on the level of abuse that's happening on it, and if it meets a particular threshold, especially in the case of website content abuse. Similarly, once you've established that there is a particular threshold for action, what are the actions that are actually available to DNS operators? So in the with respect to, do you want to lock a domain in terms of, and next slide, please, which has a chart of the actions that are available at the DNS level. So do you want to lock a domain that prevents a registrant from being able to change the registrant information in the TLD zone file? Or do you want to hold a domain name? Or do you want to redirect a domain name where anybody who's looking up that particular domain is redirected to a third-party page? Or do you want to transfer it to another registrar, which is predominantly done in the case of sinkholing? In particular, what's very important is that more often than not, people will say you want to delete the domain. What happens with deleting the domain is that it does not necessarily, address the abuse that's happening on the name server underneath, but it also, when you delete a domain name, it becomes available for being re-registered by anybody else. And more often than not, the perpetrator of the abuse can pick up that domain name and register it and continue to do to perpetuate the abuse. So it's very important to be also clear on what sort of action you're actually looking at. Do you want to mitigate the abuse, in which case it's better to lock and hold? Do you want to make sure that you want to study traffic to ensure that that this kind of abuse does not happen again? So then you redirect and transfer, what's called sinkholing, so as to ensure that you can log the traffic to understand how people have gotten to that particular domain name, how are they interacting, how to get more information from people who've been phished or from victims. So that's something that's also extremely important. What's also important to note that when you're acting at the domain name, it's not just the domain name that you might be taking down. You might also be affecting a lot of you might be imparting a lot of collateral damage, in particular when that domain name is linked to something that is much larger. For example, taking down facebook.com would result in access being revoked for everybody who has a Facebook profile. So, and there is no way to act at the domain name to splice a certain piece of that particular domain. At the same, you might also have mail servers configured to those particular domain names. So taking down facebook.com or, for example, ajithfrancis.com, and there's a corporation called ajithfrancis.com, and they have employees of 10,000 employees that are using their mail infrastructure and a lot of other infrastructure based on it. And somebody has been sending out child pornography on one of those email addresses. Can you take down the entire domain name ajithfrancis.com, knowing full well that it has mail servers configured to it or is providing access to a lot of other people? Is that appropriate? That's the kind of the tensions and jurisdictions tensions and thresholds that we try to address at the domain name in the toolkit. Next slide. Perfect. So I will pause here if anybody has questions on the domain name abuses toolkit. I see that there's one already in the chat. How do you deal with false positive reports of abuse? If, for example, someone reports his competitor as an abuse. That is a very interesting question for two reasons. One, yes, there is a lot of issues with false positive reports, and in particular, we'll see that also when we come to content moderation. It also has larger issues because of the word competitor, because that can also imply IP and IP-related issues, which are also extremely prevalent on the domain name system as being one of the main forms of takedowns. So more often than not, registry and registrar operators will require a court order to action on a particular abuse as long as it's not technical abuse. So for technical abuse, it's very clear. You have data systems to define whether a particular domain name is actually engaging in phishing or or is deploying malware. So it's very straightforward to determine whether technical abuse is being perpetuated by a domain name or not. In the case of website content abuse, it's significantly different because you need to analyze and evaluate whether this piece of content or the plethora of content that's hosted on a domain name is actually meeting the threshold for acting on. So this is why most registry and registrar operators are very hesitant to act on content requests or content orders unless supported by a court order. Increasingly, more and more registries and registrars are taking action on things that are vehemently illegal, vehemently objectionable and harmful, and at the same time illegal, such as child pornography. Some registries and registrars take down terrorism-related content and dedicated websites or domain names to for terrorism purposes, but that predominantly depends on the terms of services of different registries and registrars. And this is why the toolkit is also extremely important, is because there are components in the toolkit that allow to inform notifiers on how to better make notices. What are the things that you need to demonstrate to a registry or registrar operator to ensure that actually get their attention and to communicate and demonstrate the actual harm that's being caused that can improve the quality of the request and the level of action or the speed with which action can be taken. If that answers your question. If there are any other questions, either feel free to put it in the chat or you can ask me now. I'm also conscious of the time because I believe we have about 10 more minutes. So if there are no more questions, I can move on to the third piece, which is on content moderation. If you move to the next slide, please. So with the toolkit on cross-border content moderation, where we address the challenge of when something is posted on the internet, it's accessible globally. When can it be taken down, and what is the extent to which it's taken down? Say, for example, I post a particular piece of content on a social media platform from Germany, which is infringing on the laws of another country. Say, for example, I tweeted about a particular head of state of another country where necessarily lèse majesty laws in the country where I'm posting that particular piece of content might not necessarily explicitly prohibit it or might not make it illegal, but the head of state against whom I am actually speaking about might actually, their country might actually criminalize that behavior. So how do you particularly take action on such content? How do you define the thresholds for action? How do you also resolve the jurisdictional challenges between the illegality of different content? And at the same time, how do you also define the thresholds that service providers are setting down in their extensive terms of service and community guidelines on when they take action? In particular, one of the things that we've been focusing on is to help guide the discussion on such principles or on such action based on four principles. How do you identify problematic content? What is the typology of problematic or illegal content in terms of things that activities that are on the internet or speech on the internet that can be criminalized, and there's a whole list of typologies that we've developed. Similarly, at the same time, how do you also evaluate a particular piece of content? What are the thresholds? How do you take action? Should that action be global? Is the action based of a court order, or is it based off terms of service and community guidelines? And also, how much? What is the extent of that particular action? Should it be taken down globally, or is it only illegal in one particular jurisdiction, so it's made illegal, or the access to that particular piece of content is only blocked in that particular jurisdiction, while it's accessible from outside of that territory? These are, again, some of the elements of geographic scope that we're increasingly focusing on, because the question of geographic scope is something that most actions are not contemplating, because by default, action on the internet is global. We want to revert that to become action when it's based on national law to be by default limited only to that to the jurisdiction of that country. This is something that's extremely also increasingly problematic, because there are two ways to approach it. One, there's the notion of countries enforcing their own normative thresholds on users around the world. But at the same time, you also have challenges with regards to the proliferation of illegal behavior around the world, child pornography being one, terrorism being another, but also hate speech. So how do we define when does bad speech become hate speech? These are some of the challenges that we also work with our contact group members on, identifying the thresholds for acting and what are the things that need to be taken into account. And once you have acted on it, how do you also provide recourse mechanisms? How do you notify users? By when should you notify users? What does that new user notification entail? Is that information about taking action or demanding recourse? Or is it purely administrative to say, hey, we've taken action, we've taken down a particular piece of content? Next slide, please. So, yeah, as I was saying, so these are the four pieces of framework that we help lawmakers and platforms understand and come to terms with on how to sort of address content moderation. And there are specific tools that allow those actors to work on their content moderation policies. Next slide. One of the things that we've been working on in terms of concepts is also something called the International Normative Coherence, where we're trying to develop a mechanism by which we can not necessarily unify or harmonize international law, but at least provide a framework or quantitative measurement or mechanism by which you can sort of take action on content that might be illegal in sufficient jurisdictions, or not take action at content that's problematic at all. The first one is when there is universal agreement that a content or behavior is illegal and there is strong substantive convergence around the world on the corresponding threshold criteria. Example, child sexual abuse material. So this becomes bucket one of international normative coherence, that when it's bucket one, it is so bad and it is illegal around so many jurisdictions that that action at a global level might be relevant. It still requires evaluation of the threshold and also on the exact kind of harm that's being put into place. But if it meets that threshold and it is in category one, there might be sufficient grounds to act globally. There's bucket two, which is when there is universal agreement that the content behavior is illegal, but there is significant national variations in determining the illegality. Defamation is the primary example. While defamation might be illegal across most jurisdictions, the standard with which you approach defamation varies from country to country. One country might set the threshold extremely high on defamation, while another country might set it extremely low. So how do you also, when you have a case of defamation or any case of content that falls into category two, how do you sort of approach the question of this meets that particular standard? In particular, let's say the standard in defamation in the United Kingdom is much more stringent than the standard for defamation in India. So can a judge in the UK say, because my standard is one of the highest standards in defamation around the world, that there might be a legitimate argument to take a particular piece of content down globally? Similarly, the third bucket is when a particular piece of content is not considered illegal universally, but there are application of specific domestic laws on the local territories considered acceptable by other countries. For example, the criminalization of Holocaust denial. While Holocaust denial might not necessarily be illegal around the world, there are certain specific jurisdictions, like France, for example, that criminalize the denial of Holocaust. So it might be relevant to take action or limit a piece of content that's denying the Holocaust in France, but it might not necessarily resulting in impacts in other jurisdictions where it's not illegal. And the fourth bucket, which is where a particular piece of content is not universally considered as objectionable, and some countries even consider that it should not be allowed to making it illegal. Homosexual crimes against criminalizing certain sexual orientation. If I'm having a lot of disturbance, if you could mute whoever is speaking, thank you. So yeah, those are the four buckets of international normative coherence. And this is also my last slide. So if you have any questions, feel free to put them in the chat or take the floor to answer them now. I see Glenn has put in a question, which is, how do you deal with the variance in interpreting criminal behavior versus your First Amendment of freedom of speech? Glenn, that's a very interesting question, because freedom of speech is not it's not an absolute right. There are mechanisms for limiting freedom of speech in certain situations that are codified in international law. Also, the threshold that the First Amendment in the US sets is not necessarily the threshold that's applicable on freedom of speech around the world. For example, in the UK, defamation is considered to be part of private law, and under private law, there is legitimate grounds by which a particular jurisdiction may consider the enforcement of that particular takedown order across jurisdictions in order to prevent harm to a particular victim. Under public law, it becomes a very different and a complicated argument, because it becomes one state enforcing its normative threshold on another state. But private law does make the exception for when it is affected, when individual victims are affected. So again, there is a lot of variance between freedom of expression. Platforms are increasingly also reverting to their terms of service and the community guidelines as the baseline for that conversation. It is an extremely complicated scenario, and there is no right answer. There are, on the other hand, a lot of countries that are increasingly passing their own online harms laws or digital services acts. In the case of the UK and the EU, increasingly, Turkey is also in the process of instituting intermediary guidelines, as is India. So a lot of countries are defining their own, or setting up their own thresholds for what is illegal and what is criminal in the digital realm, which is resulting in a legal fragmentation of the jurisdictions and the laws that platforms need to abide by in different jurisdictions. So that's, again, another extremely complicated challenge, especially for smaller platforms to navigate by when they're providing services globally or by default on the internet. And they have to now pay attention to intermediary guidelines and restrictions in different parts of the world. And they are also required to define and designate legal representatives in those jurisdictions. So it is extremely complicated, and which is where consensus-based multi-stakeholder conversations on these issues to define the thresholds and the procedures is extremely important. And this is the kind of work that we focus on, because there is an absolute gap in conversations where different stakeholders can come together and define what should be the level of threshold or the course of action for acting on specific types of abuses. And this is why multi-stakeholderism is extremely important, and we're one of the few platforms that are doing it, but there are other platforms that are also increasingly engaging in multi-stakeholder consultations and defining the thresholds of the processes by which regulatory interventions are taken into account. So with that, I leave it there, and I open up for any other questions if there are. If not, that's the end of my slide, and I hand back to Glenn and Alfredo.
Great, thank you. I think we've been dealing with a number of questions all the way through the session, but I think they're starting to come in now. Mira, thank you for your question. She asked, how do you deal with the bias in censorship?
Would you mind clarifying what you mean by bias?
I think she's typing that up. So folks, if you have any more questions, we have a few more minutes with our guests today. Please type in your questions. There's a slight delay in terms of what she means by bias.
While she does that, Glenn, Ajith and probably Sophie, when you started out with your chat, you mentioned the process, the legal process, and the jurisdiction, who has the legal right to interfere or to do some recourse or whatever. My question is, what happens if there is an event and the process is so long after the fact to deal with whatever happens, how does that resolve the issue? Thank you.
Well, this is there are two ways to look at it, right? I mean, you have sort of one, traditional legal mechanisms are ill-suited for handling recourse on the internet because one, they take so much time, but you also need that amount of time to also provide due process guarantees and representation. So on the other hand, you have also increasingly, and we're seeing that scale is again a question, an extremely big, important question here. And if you look at the transparency reports of different platforms, you'll see that, you know, the amount of volume of content that they are moderating and they are sort of acting upon is significantly high. And there is an increasing challenge where we will not be able to provide human review in each and every case. And there is a very good argument for let's say artificial intelligence or algorithm-based moderation practices, but that makes recourse even more important. And which goes to the crux of your question, Alfredo, that recourse cannot be something that takes weeks and months and years, as we see with the Facebook Oversight Board as well, with the board that Facebook has constituted as a recourse mechanism once all appeals within Facebook have been exhausted. They take 6 to 12 weeks to publish a case judgment, and they are a board of about, I'm not sure, they want to go up to about 40 people, 40 members in the oversight board, and even they are only able to handle a tiny percentage of the number of recourse cases that are sort of administered to the oversight board. So it is a question of, and that's an extremely important question that's only going to grow as more and more content is posted online. We need more and more content moderation, and we need faster content moderation, and we need more effective content moderation to minimize harm. But at the same time, we also need to ensure due process and ensure we have agile mechanisms for facilitating due course and providing and fulfilling due process guarantees. So it's a very complicated system, and we're only grappling at very small issues of the same. Does that help, Alfredo?
Yes, it does. Thank you. Mira is back.
Yeah. So she it says for clarification, she's saying if a government or association wishes to hide certain posts or stories and labels them as offensive. So for geopolitical reasons, religious reasons, whatever. So how do you broach that issue of selective censorship? That's what I think she's getting at.
Absolutely. Again, a very good question, right? I mean, and I come from it from the perspective of INJ, where again, there is a challenge here because you have to. Well, countries within their particular jurisdiction have the sovereignty and the authority to sort of deal with that particular piece of content the way they deem lawfully appropriate within their jurisdiction. The challenge becomes when that government or association wants to exert its needs to hide a particular post or stories outside the jurisdiction, which is an even bigger problem because now that country is going over and above its remit. And we're increasingly seeing examples of not just governments trying to hide certain posts or stories, but also increasingly countries and jurisdictions and courts taking action on content that's potentially illegal in their country, and they're making extra territorial pronunciations of jurisdiction of the sentence. So this is an extremely complicated thing, and I don't want to get into the question of whether a country's mechanisms are appropriate to define what is illegal in its jurisdiction or not, because that varies from country to country, and there are bad countries out there, and there are also good countries that make bad decisions and bad requests. So I don't want to get into that question, but it does have an impact when it is cross-border or when it is affecting the global accessibility of that particular piece of content. And that needs to be very delicately handled because there are certain, we do recognize that there are certain situations where you need to have extraterritorial impact. But those are very few, and those are exceptional situations. And you need to define that they are exceptional situations and demonstrate that they are exceptional situations. While at the same time, if a country wants to limit a particular piece of content within its own jurisdiction and it has the legal basis to do it, they are well within their right to do it within their jurisdiction. With regards to your second point on bias from the moderator, projecting their personal views, yes, that is a challenge. You need to sort of train moderators and improve capacities of moderators, but you have to also strengthen recourse mechanisms and the process of content moderation. And it goes to the previous point that I was making, is the scale of content that we're dealing with. And from the recent transparency reports, I mean, content that's taken down based on illegality is only 1% of the total content that's acted upon on Facebook. Remaining 99% is based on terms of service related or community guidelines based decisions. So that's predominantly based on moderator decisions. The more moderators make decisions, the more important it becomes to have recourse and mechanisms to sort of challenge the decisions that have been particularly taken. You have to also factor in that there's a pulling tension between addressing the harm or something that might potentially be harmful at the fastest, but at the same time also ensuring freedom of speech. And these are conflicting tensions that we need to reconcile with additional mechanisms for recourse, for institutional mechanisms by which guidance can be provided to content moderators, and by the way with which we design and deploy algorithmic-based content moderation tools. They need to have better data sets, and they need to also be trained to ensure that they're taking into account that there is some sort of human review at some particular form.
Thank you. Let me jump in on this issue. It's probably more of a legal issue than a security issue, but many countries, particularly if you are in London or in Singapore, in many countries, cameras are everywhere, and law enforcement is using artificial intelligence. But we're seeing a clear bias on in terms of the software writing and the depiction of certain groups. So darker skin tone individuals are possibly confusing the algorithm, but there is an issue here in terms of the lack of unbias with this AI. So how do you address the issue of bias within AI?
Bias within AI is, I think, a completely huge issue, which is a much more systemic issue that is much harder to sort of get at. I can tell you from the other side, though, as more and more countries are deploying artificial intelligence for surveillance practices, they're not defining well enough the due process safeguards and guarantees that are also sort of supposed to accompany these surveillance and privacy invasive mechanisms. So I would focus more on that perspective, because on the AI data sets, that's a systemic issue that I don't necessarily have an answer to. That's something that I grapple with as somebody who is who fits within that identifying dynamic as well. I struggle with that on a daily basis, but I don't have an answer on how to address bias in AI. But I do know that on the legal side of things, that there's a lot of ways that which we can focus on defining what are the processes and the judicial processes and the thresholds by which that surveillance information should be accessible. It shouldn't be 24/7 accessible to any police officer. There needs to be demonstrable cause, probable cause, or the standard of proof needs to be concrete enough to access it, and it's not something that needs to be perpetually existing. So those kind of elements are, again, something that is missing in the legislative framework and the regulatory framework, because, again, there is the speed with which the technology is evolving is not adequate enough is so high for the regulatory measures to catch up with, that the delta is extremely high.
Right. I just wanted to ask both of you, Sophie and Ajith, do you have any events coming up that you would like to share with us, that which are virtual or else otherwise, that you'd like to share with us for people to join those sessions?
Yeah, sure. Thank you. Thank you for that question, Glenn. So we have we're still fixing a date, but in sometime at the end of June, we're likely going to be organizing a webinar with the Center of Trade and Investment in Geneva on data, the issue of data and trade. If that's a topic that's of interest, I would definitely be happy to send you the registration for that. It's actually based off a report that we launched a couple of months back on the topic of data sovereignty and data free flow. So how we can kind of frame the debate around these two very polarizing policy concepts of data of sovereignty, need to have data localized within a country, or cross-border data flow. So I'll put the report in the chat so people can see that, and I'll happily share the registration details with you when we have them.
Great.
And also, I'd be happy to keep you all updated on how our future projects in Africa may go. As I mentioned, we have the Latin America Regional Status Report, and we're looking at how we can evolve that into doing something specifically with the Africa region. So I definitely loop you all into that as well.
Great, thank you. Alfredo?
Well, just some final words. Your presentation was excellent. We have been sharing some of your resources on the different modules we have, and actually in the Spanish version I already have the report embedded as part of the complementary resources, so thank you for that. And we hope to hear from you in the future, and as Glenn mentioned, the fact that you have future events in the works, we would be glad to share it with our close to 400 plus alumni in the program as we move forward. So thank you, Ajith and Sophie, for that. Back to you, Glenn.
Okay, thanks for everybody for joining us today. I realized we've gone a little longer, but it was an excellent presentation. Thank you so much for being here today, and we're happy to share the resources, and hopefully people that are on the call today or other people that will watch the YouTube video, they actually can take advantage of connecting with you guys and doing something local. So again, this was one of the highlight presentations we've had this year. We're midpoint in our program, and we are trying our best to fill in the gap that exists in the material, just like what you guys found a huge opportunity to do what you guys are doing, because it was a huge need. Again, thanks again, and thanks everyone, and we'll see you all next Monday. Thank you.
Thanks a lot.
Thank you.
Bye-bye.
Bye-bye.
Bye to all.